All right, welcome to this makeup class for introduction to commencement of legal actions. As you are aware, we didn't quite do our class on writ of summons properly, as we were having challenges here and there with the platform and the network. So we have decided that this should be a makeup class to what we had covered in that particular class concerning writs of summons, or basically commencement of legal proceedings. So I'll be your facilitator. My name is Jason Kausa. And today, let me share my screen. Today we'll be looking at what we had started in that particular class. It is more of a recap of what we had already done in that particular class. So I'll be sharing my screen, and I will share my slide of everything that was supposed to be covered in that particular meeting. Okay. So as I have mentioned, we're dealing with commencement of action, okay? Commencement of action is what we are dealing with. Now, what you have to understand is what is commencement of legal process. What do we mean when we talk about commencement of legal process? Well, commencement of legal process simply refers to the application or the starting of a legal matter in a court of law. It could be against someone, or it could be to obtain a particular order from a court of law. That's what commencement is. And this is referred to as legal process. Okay? So it is referred to as legal process because you file into court certain documents that we call processes. So every document that you get to file into court is called a process. This is different from other documents that you draft as a lawyer, but you do not file them into court. Okay? Those are not part of what we're calling legal process. Only those that you get to file into court are called legal process. And as it has been mentioned over and over and over in this foundational course for the LPQE, we are dealing with documents that are part of legal process. Okay? So every time you hear the term legal process, I want you to associate it with documents that you file into court for purposes of this class, of course. Now, we're looking at how someone can commence this legal process. And we agreed in our last class that we discussed that there are numerous methods or numerous ways that a person can commence a legal matter in a court of law. Okay, some of which are writ of summons, default writ of summons, petitions, originating summons, or originating notice of motion. Those are the modes that are provided by law that one can commence a that one can commence a legal process in a court of law. Now, this class is concerned with the first one, the writ of summons. And in trying to discuss this writ of summons, you will note that there will be some references that will be made to a default writ of summons. But I do not want you to get confused, because the document that we're going to share in terms of trying to understand fully how this writ of summons looks like is one of a default writ of summons. And that you will see how a default writ of summons and writ of summons are different. Generally, they're the same, only certain sections make it a default writ of summons. Okay, now, for us to understand what a writ of summons is, we have to understand the words. What does it mean? Okay, in our last class, we did mention that we separated the word writ of summons. We looked at what writ means and what summons means. So the word writ, as I had mentioned in our class, simply comes from the word return, to write. Yeah, to write. So particularly when we're talking about a writ, we're referring to something that is written. And at law, when referring to the word, or when we use the word writ, we're simply speaking to a written document that is issued under the authority of the Chief Justice. Okay? It is a document that is issued by a court. All right? It is a court document that is issued by a court. And because it is written, we're saying it is a written document issued by a court. This particular document is instructive. Okay? It is instructive to the person to whom it is addressed. So this written document, the whole purpose of this document is to instruct someone to whom it is addressed. If it is addressed to you, then it is instructing you on what you need to do. The word summons means a call to appear or to respond. Okay? A call to appear or to respond. That is, the defendant is summoned, okay, to court to answer the plaintiff's claim. So when you are summoned, you are called by a court in a written order to go and respond to the claims that the plaintiff has brought against you. All right? And what is important to note is that when this is done, okay, when this is done, it is not an optional thing. So altogether, when you put them back together, writ and summons, you put them back together, what you're going to have is a written order issued by a court that is a call to a defendant to appear before a court or to respond to the claims of the plaintiff. That is what a writ of summons is. It is a document that we use to instruct somebody for whom you are bringing a case against to say, this is a case I'm bringing against you. You should come and respond to these particular claims. And I have mentioned that this call is not an optional call. It isn't an optional call. You are supposed to respond to that call when you are called, okay? When you are saved with the writ of summons, you are supposed to respond to that writ of summons. If you do not, the court and the plaintiff will move and the court will give judgment. The court is going to give judgment in your absence. And that is what we call a default writ, or a default judgment, sorry. Now, what are some of the courts, or what courts use this mode of commencement? You have to understand that it's not every mode of commencement that is used in every court. There are certain courts where you're not going to use certain types or certain modes of commencement. A writ of summons, for example, you cannot use it in the Court of Appeal. Now, there are only two courts that use this type of mode of commencement, the High Court and the Subordinate Court. And for purposes of this class, we are simply looking at the writ of summons in the Subordinate Court. We're not looking at it in the High Court. So I want you to keep that at the back of your mind as we are looking at the nitty-gritties, the details of this writ of summons, because there is a difference between a writ of summons in the Subordinate Court and a writ of summons in the High Court. There is a difference because Order 6 of the High Court Act states that a writ of summons should be accompanied by a statement of claim, an affidavit, and all those other documents that are required to accompany it. But when you go to Order 18 of the Subordinate Court, it says that matters in the Subordinate Court are supposed to be handled summarily. What this means, the implication of this is that there are no pleadings in the Subordinate Court. And what are pleadings? Pleadings are these very things that we're looking at. The writ of summons, the statement of claim, the affidavit. When you put them together as a bundle, that becomes pleadings, okay? And in the Subordinate Court, according to Order 18 of the Subordinate Court Act, it is saying that there are no pleadings in the Subordinate Court because matters are supposed to be handled summarily. Unless the court itself demands or orders that you should file into court these pleadings, statement of claim, or affidavit. So that is the difference between the writ of summons in the subordinate court and the writ of summons in the high court. Please keep that in mind as we are moving forward. Okay, so now we have to understand what this writ of summons is used for. Okay, you have to understand what this writ of summons is used for. What kind of cases can you bring to court using a writ of summons? It is important that you understand that. Firstly, when you're bringing a matter before a court for a claim of an unliquidated sum, and what we mean when we say unliquidated sum, there it is written damages, it simply means sum. We're saying an amount that is not quantified. All right? You have not quantified the exact amount that you're asking the court, or that you're asking from the court, or that you're asking the court to award, right? So when that is the case, for example, in a case of negligence, then you are using a writ of summons, okay? You're using a writ of summons. But where you have a specific amount, that is liquidated damages, you use a default writ of summons. And we'll look at that in a different setting, all right? The last thing are the endorsements that you put on a writ of summons, and this is what differentiates the writ of summons in the subordinate court to the writ of summons in the high court. It is what you endorse upon that writ of summons. Okay, the writ of summons in the subordinate court, you endorse upon it what we call a brief statement of claim. You endorse on it a brief statement of claim. And that brief statement of claim is what gives the defendant an idea of what they are going to court for. It what discloses the cause of action. Okay? It discloses the cause of action. So it is not a separate document per se. Okay? It is not a separate document. It is endorsed upon the writ of summons. It is on page 2 of that writ of summons. All right. So when the document is drafted, then you're going to have those endorsements. Now I'm going to move to a sample of a writ of summons. I'm going to stop sharing this particular window, and then I'll start sharing a sample of a default writ of summons. Okay. So I'll go back here and stop sharing. Then I'll start sharing again. And then I will share this particular document. Okay. I am sharing this particular document. Oh, that was my mistake. Okay. What you're seeing here is a writ of summons. And this writ of summons, you can find it in the first schedule to the Subordinate Court Act. Now, you're seeing there that the writ of summons I'm sharing on the screen is for the High Court. Yeah. In the interest of time, I will go with this one because there's something I need you to learn about that particular aspect. We're supposed to be using a writ of summons from the subordinate court. Okay. So what you have on top there, you have Republic of Zambia writ of summons for issue from the principal registry. And what you have there is in the High Court for Zambia at the commercial registry. I want you to since we're learning how to draft, okay, since we are learning how to draft, that part is the heading. It shows where this document is coming from and where this matter has been started or where this matter has been commenced. All right. If you're in the subordinate court, this is going to read in the subordinate court for Zambia. Okay. That is how it's going to read. Secondly, you have the parties clause. That shows who is involved in this matter. if you're the one receiving this particular document, you are going to note that it is going to bear the name of the plaintiff who is suing you and your name as the defendant. And after that, it gives, this is the first endorsement that is there, okay? This is the first endorsement that must be made on a writ of summons. To whom is this addressed, okay? So the defendant's name, the defendant's plot number or house number, then the defendant's post office box, right? The second thing that should be endorsed on this document, and it's not here, is you as the plaintiff, okay? It must be endorsed by your name and your post office box or PO box, your address, and house number. Those are things that must be endorsed on a writ of summons. Failure to which the writ of summons will be said to be irregular, okay? It will be said to be irregular. The second thing is what we have is the command clause, right? This writ is issued out in the name of the president, okay? You are commanded in the president's name that within 21 days, now that 21 days, Council Blessings labored to explain why it is 21 days, why it is 30 days, why it's 45 days, and so on and so forth. It deals with the distance of the place of service from the registry. So the court, the court registry is, if you're 100 meters within or outside the court registry, within the court registry, or from the court registry, let me put it that way, then the days for which you're supposed to respond in is 21 days. Outside that, the days continue to go up depending on the distance, all right? So we're talking about the court registry and the place of the defendant, where you're supposed to serve this particular writ, okay? So the 21 days is the number of days that you're supposed to respond within. That is the command clause, and it mentions who is suing you, all right? It mentions who is suing you, and also gives you notice, right? I mentioned earlier that when you receive this writ of summons, it is not an option that you respond to it. You must respond to it. So it is giving you notice. Take notice that in default of your so doing, that is entering appearance, the plaintiff may proceed therein and judgment may be given in your absence, all right? Judgment will be given in your absence. The second clause is a testimonium clause, all right? That bears witness to say that this document was given under the authority of the Chief Justice. It is a legitimate document. That is the testimonium clause. Witness the Honorable Mr. Justice Mumba Malila, who is the current Chief Justice of Zambia, the dash day of March in the year of our Lord 2003. Now, that is a drafting thing that you have to notice there. The date clause is in words, all right? The date clause is in words. It's not in numbers, and you must put it as such, all right? You must put it as such. For examination purposes, I repeat this, for examination purposes, leave it as it is like that, all right? Leave it as it is. Okay, so moving forward. Now, this is the first endorsement, okay? This is the first endorsement. This is something that is supposed to be put on the, this is the other endorsement that is supposed to be put on the writ of summons, okay? Memorandum to be subscribed on the writ. This, remember I said that a writ is an instructive document. This is some of the instructions that a writ actually makes. This writ is to be served within 12 calendar months from the date thereof, or if renewed, within 6 calendar months from the date of the last renewal. That instruction is for you, the plaintiff. It is for you, the plaintiff, to say that is the lifespan of this particular writ. When you take it out of court, that is the lifespan. You must be able to serve it on the defendant within 12 months. thereafter, this writ will be invalid. Okay, it will have expired. So it is instructing you of the amount of time you have, the period in which you have to serve that writ. Secondly, saying the defendant may appear hereto by entering an appearance, or appearances either personally or by solicitor. This is simply just giving instruction to the defendant to say they can appear personally or through a lawyer. Okay, they can respond to this writ that is issued out or addressed to them through their lawyers or by themselves. Where do they enter appearance? At the High Court Principal Registry. Remember, I mentioned that this is a writ in the High Court. Even if we're dealing with a writ in the subordinate court, you're supposed to note these differences. Okay, if it is not in, if it were in the subordinate court, the registry there would be different. Okay, the registry would be different, and this directs also the defendant where they're supposed to enter their appearance. If the writ was issued out in the Lusaka district of Lusaka province, you live in Kafio district, there's no way you're going to enter appearance in the subordinate court in another district. Okay, that cannot be done. All right, that cannot be done unless exceptionally. Now, the third one is a defendant appearing personally may, if he desires, enter his appearance by post, and the appropriate forms may be obtained from any High Court registry or from any subordinate court office. Now, this is a different issue. I'm from mentioning that if the writ is issued out in the subordinate court in Lusaka, okay, and you're in a different district, now, you note that I mentioned the 21 days in which you're supposed to respond, okay? Depending on the distance that you are from the registry, you'll be given more days. But if it so happens you're in a situation where even those particular amount of days, you'll not be able to make it, you can appear, okay? You can enter appearance by way of post, okay? You can use post and then you enter appearance. And this is the whole purpose. This is the instruction that is given under this particular memorandum to be subscribed on the writ. This is how the writ of summons is instructive. The second part is endorsement to be made on the writ before issue thereof. And this is where now, if you've been following, you will note the difference between a writ of summons and a default writ of summons. I had mentioned earlier that a writ of summons is a document or is a mode of commencement used for civil matters where the claim is for an unliquidated sum. All right, it is not a specific sum. A default writ of summons, on the other hand, is a mode of commencement used for civil matters where the claim is for a liquidated sum. Now, furthermore, I did mention that in the subordinate court, the writ of summons, either default or writ or just general writ of summons, is not accompanied by any particular document because matters are supposed to be handled summarily. There are no pleadings. So there is no affidavit, there is no statement of claim, all right, unless the court orders so, Now, what you have here is what we call a brief statement of claim. It is a brief statement of claim, all right? And it says the plaintiff's claim is for 4,907.77 cents United States dollars, being the balance of the price of goods supplied and delivered by the plaintiff, and interests and costs. You will note why we're using interest and costs when we're dealing with a default writ of summons. This statement, this claim here, makes this entire writ not a general writ, but a default writ of summons. Why? Because the amount there is specific. Okay? The claim is for a liquidated sum. All right? Liquidated damages. So now I'm going to show you how you're supposed to draft in a general writ, not a default writ. Everything else is the same. What changes is this one here, the endorsement to be made on the writ before issue, this brief claim. Now, let me stop sharing this particular window and share a different one. Okay, this is the document I want to share with you. Okay, firstly, as you see what is written there, an endorsement is the brief statement of claim of the claim. Okay, so this is the cause of action, the claim, what you're asking. The endorsement on the writ is very important because there is generally no requirement for pleadings, generally. And remember, where there's a general rule, there is an exception. And the exception is that unless the court orders that you should file into court these pleadings, that is, writ of summons together with statement of claim, defense, and counterclaim. Okay? As such, the endorsement on the writ of summons is the only way the defendant or anyone else reading the writ can have an idea of that claim. The endorsement is on the second page of the writ and ordinarily reads as follows. Okay, so this is an example of how this claim is supposed to be. The plaintiff's claim is for damages for breach of contract dated 12th of July 2016, made between the plaintiff and the defendant for the sale of motor vehicle registration number ABL 2000. You will note that there is no amount. Okay, the claim is for damages for breach of contract, but there is no specific amount as to how much you're asking the court. All right, that is what happens in a writ of summons. Where you see that there are specific amounts in the claim, then you know that this is a default writ of summons, and the rules are different altogether. Okay, the rules are different altogether. That is something that I want you to be very, very conscious about. Okay, so we get back to this document. This will be different in a writ of summons. Okay, so I want you to note every difference that you see between a default writ of summons and a writ of summons. I want you to learn what is supposed to be in that particular writ of summons for it to be a full writ of summons. okay? So that if you're able to see a writ of summons, you'll be able to actually see, the mistakes, you'll be able to see errors, and you'll be able to correct that particular document. That is very, very important, okay? That is very important. The next one is the clause that now talks about who issued this particular writ of summons. This one was issued by Musa Dudia and Company on behalf of Samora Machel, on behalf of the plaintiff. That's where they live. Sorry, that's not their name. On behalf of the plaintiff who lives at that particular address to the defendant, okay? And then there's the date on which this particular document was issued, and that should be left blank for purposes of the exams. So that wraps everything about a writ of summons. Generally, everything about a writ of summons. That wraps it, okay? That wraps everything about a writ of summons. And that's all we need to know. That's all we need to know about a writ of summons. If there are questions, colleagues, you are welcome to ask in the group. You are welcome to send questions through the email, or generally just save them for our next meeting, when we'll be looking at a default writ of summons. And since we've looked at a writ of summons thoroughly today, I can state that it won't be much work to look at a default writ of summons, because all that makes it different is the endorsement, the brief claim that we have on the default writ of summons, okay? The brief claim that we have on a default writ of summons. And given the fact that Council Blessings has actually labored to explain and, tutor on how to draft a default writ of summons and what documents are supposed to be accompanying that default writ of, he has belabored to explain the affidavit verifying debt, which is supposed to accompany a default writ of summons, and the documents that are supposed to accompany an affidavit verifying debt. I believe there won't be much to look at when it comes to a default writ of summons. If the court orders that pleadings should be filed into court pursuant to Order 18 of the Subordinate Court Act, the kind of affidavit you're going to attach to a writ of summons is an affidavit verifying facts, okay? Or an affidavit an affidavit verifying facts, or an affidavit in support of writ of summons, okay? That is what it is called sometimes. Sometimes it is called an affidavit in support of writ of summons, or an affidavit verifying facts. So generally, Council, that wraps our class, okay? That concludes our class on a writ of summons and opening up these modes of commencement classes. The next thing that we're going to be looking at, of course, is a default writ of summons and some other form of writ of summons. We also have to look at the writ of summons in the High Court in our next class. So we have a lot to look at. I would advise you to actually familiarize yourself with this particular mode of commencement as we proceed. This covers everything that was supposed to be covered in that particular class. And I'm glad to say this will be sent to everyone. If you have questions, again, send them in a group or save them for our next class. Thank you very much.